Welcome to the fourth annual symposium sponsored by the Center for Law, Technology, and the Arts. My name is Craig Nard. I am a professor here at the law school and director of the Center for LTA. Today's topic is perhaps the most controversial and one of the most important topics at the intersection of law and sports. And we have the good fortune of having a group of distinguished and talented participants to explore this issue, all of whom will be introduced by the symposium coordinator, or at least our initial panel will be introduced by our symposium coordinator, Peter Carfagna. Let me say a few words about Peter before I turn it over to him. Peter is a senior counsel with Kelfie, Halter, and Griswold in town, and Case Law School's first distinguished visiting practitioner. Before joining Kelfie, Peter was general counsel at IMG for several years, and before that at Jones Day, and has had the opportunity to delve into these important issues for some time. Please help me in welcoming Peter Carfagna.
Well, thanks to Craig, and welcome everybody this morning. And a little wake-up call. We're going to sing "Take Me Out to the Ball Game." Cue the Star Spangled Banner, please, and away we go. No, really welcome to what I think is going to be a really exciting symposium. I want to start by congratulating Craig himself on his recent appointment to the Tom J. E. and Betty Lou Walker Professor of Law Chair, and I think we should give Craig a round of applause for great accomplishment and his building of this wonderful institute of which we're all proud to be part. Craig has nurtured our sports law and entertainment course along from its very beginnings, and week by week I would send him my little hypotheticals about what we were doing at the IMG legal department with the names changed to protect the oftentimes not so innocent. And Craig would say, "That's a good one, try that," and that's another really good one, try that. And we found ourselves, some of our students are here, we found ourselves, and former students, Matthew, having a lot of fun with these hypotheticals because there oftentimes is no right or wrong answer. We found at the beginning we dealt with right of publicity, which for those of you who don't practice in these areas, I think would find instructive because it manifests itself in what we're going to be talking about today, and that is what rights do these athletes, what rights inure to their benefit as they develop their career. So as we go through with Eve and our distinguished panel with the individual sports in particular, and Chris is going to speak about golf, tennis, and Olympic athletes. When does that person have a bundle of rights? These people are walking, talking bundles of rights that are walking around that are saleable, and then when do the rules permit them to sell those rights? And what should those rules be? So we like to talk about the normative aspects of these rights of publicity. And, when can somebody make a poster and benefit from a poster of a Tiger Woods? We talk about that a lot in our course. And when do those rights become public domain rights? So. But as we would go through this in our course, we came to this, as Craig said, edgy part, which is eligibility. And when are you eligible to, maximize the return on these rights that years and years of training have allowed you to develop? And what's idiosyncratic about this area is it's different. There are different rules for each of the different sports, and that's what we're here to talk about today. And I would just invite each of you to be sort of judge and jury as we welcome you to these issues. If they're new to you, that doesn't mean you can't be smarter about them than those who are expert in them, who have tried cases in them and won and lost, or who administer them, or who represent athletes who are subject to them. But I would just, by way of introduction, suggest to you consider, what does it do to people to turn pro? What happens when a person gives up his or her eligibility ultimately? And what age is that appropriate, both from a psychological and physical and legal standpoint? That's really what the seminar is about today. And instructive in this regard are some of the examples where that has worked, and other examples where it has maybe not worked so well. And we can talk about many of these cases that have become public over the years, but you go all the way back to challenges to the tennis eligibility rules, especially on the women's side. and you look at what has happened to some of those women, young women, and having a young daughter who was very active in sports, personalizes it for me. And to see some of her friends as she would go through her sporting career, go to a sports academy, for example, especially in the individual sport, rather than continue to pursue that sport at their school. I mean, this is the kind of pre-professionalism we're talking about. And then see some of them going over the edge, as it were, and turning pro in golf or tennis at a really young age, rather than taking that Division I scholarship. Or. That's the kind of interface that we're talking about. When is that appropriate? And you've seen a lot of crash and burn cases in that area, because as we say in our class, what often happens in that, and we would see this at IMG oftentimes, is that's when they, despite the agents and everybody else's best efforts, stop growing. This arrested development thing can kick in, where that is who they are for the rest of their lives, a tennis player, a golfer, and in the individual sports. And are those rules better or worse than some of the team sport rules, where are we protecting or patronizing? Question. This is a panel's going to consider that. Those kids now in the NBA, we're going to say we have to go to college for a year, before we'll even let you be eligible for the draft. Is that a right, wrong, or indifferent rule? Is that better for those kids? That rule's been challenged many times. So these are the kinds of rules that we want to talk about throughout the day. I think you're going to be really excited about our luncheon speakers, because they are people who train these athletes at the pre-professional level. They're the best in the world that I've seen. They sort of have the go, no-go on, do you have what it takes? Do you have the genetic? They'll get down to almost the DNA kind of coding aspect of, do you have what it takes to be a professional athlete, which really is the difference maker. And it's amazing the metrics that they're going to talk to you about at lunchtime that can determine at a very early age. I mean, last night we were having dinner with them, and I think it's fair to say, guys, that they said by the age of really 12, 13, 14, you pretty much know if you're dealing with a pre-professional athlete or not, in a lot of ways that can be measured. And it was really interesting. I don't want to steal their thunder, but they're going to tell you, this is interesting for all of us, that when do you want the kid, the young person, for that pre-professional training? Well, I want, what do you say? I want a young man at like age 7 or 8, no, age 8, and I want a young lady at age 7. And that's when, for the next 3, 4, 5 years is when I can maximize the return on the investment in their development dollar. So we're going to talk about all these subjects throughout the day in 3 different panels. And then after lunch, and I hope everybody can stay, especially if you're an Indians fan, we were lucky enough to get John Farrell, who's a terrific, the player development head for the Indians, and his assistant, Mike Hazen. And they're going to talk about it in the context of minor league baseball and the development of players in that system and the potential for the exploitation of, and that's going to run through these panels too, is the exploitation of some of these young athletes, depending on what the rules are, the Latin American players especially. So I think you're going to find the entire day of great interest. I just would want to share one little war story. Al Fuente, who's here, will remember the fateful day. I mean, so the question that's going to run through today is, when is it appropriate for somebody to turn pro and why? And when can they? So what are the rules? But Al and I will never forget the Sunday we were sitting in the IMG legal department as Tiger Woods was winning his 3rd amateur and deciding whether or not to turn pro. Now, that's a pretty easy case. It was pretty easy, I think, for Tiger that soon after to decide to turn pro. And it's interesting. You have to be so careful, and you're going to hear all about those rules today, not to have a deal in place, not for him to have an agent already. But that's the kind of interface. So it's easy for Tiger Woods, but for everyone, and that ends up being Tiger Woods, there are hundreds and hundreds and hundreds who go to the Ledbetter Golf Academy, decide to get off the track of the normal school that would take them to perhaps a Division I scholarship, and you never hear from them again. And the same is true in football, the same is true in basketball, the same is true in each of these sports you're going to hear about today. So that's where I would invite you to help us make the call. Are the rules appropriate? And, if it were you or your son or your grandson or granddaughter, what would you counsel them? And I guess I would come out on the other side to say I would have them go to Lauren Seagrave and Kevin O'Donnell, our luncheon speakers, and tell me at an early age if we're talking about a pre-professional athlete or not. And even if we were, my personal view is, let's take it to baseball. I would say, if you have a scholarship, unless you're going to be a 1st, 2nd, 3rd, 4th, 5th round, Joe, you may differ on this. Joe represents a lot of baseball players. unless you're going to have a really good chance at making it to the majors and making a living off of baseball, I would say take that scholarship, because that's something, even if you break a leg tomorrow, you've got a college education. And I think John Farrell's going to tell you his son, who decided to take a scholarship to the University of Virginia rather than turn pro, or Mike Hargrove, whose son had the same decision, we talked to him a lot about it, would say the same thing. Get that education if you can. Let your sport pay for it, and then see where it goes from there. So that's why we're proud to be part of this wonderful educational institution. We think this is the engine for growth in this area. And with that, I guess it's about time to turn over to our first panel. Joe Rosen is going to be our panel leader. His materials, his biomaterials are in what you have in front of you. We're really pleased to have Alan and Mike on the panel, too. You can read in front with what is in front of you, what they have done, how distinguished they are in this area, how lucky we are to have them. And they are going to explore, as you can see, NFL and NBA rules in particular, which are really at the cutting edge of this area, and I think are very instructive for the rest of the day. So thanks, Joe, for being with us.
Peter, one qualification on your comment on the baseball draftees, I would just say that it depends on the signing bonus there. Good morning. As you can see, we want this to be interactive today. This is going to be a very interesting panel. To my right is Alan Milstein, who is an attorney. He's a partner at Sherman, Silverstein, Kohl, Rosen, Podolsky. That's how I know him, as well as a devoted Philadelphia sports fan. You know him as lead counsel for Maurice Clarett. To his right, Professor Michael McCann at Mississippi College of Law he was also a member of Maurice Clarett's legal team, and he's written extensively on age restrictions and eligibility in sports, particularly in the NBA. So what we're going to do today, first of all, I want to show of hands. How many people have read one or both of the Maurice Clarett cases? Okay. Good. Well, what we're going to do today is, at first, I'm going to go over the age eligibility rules that we're talking about here in the NFL and the NBA. Then we'll go into a brief discussion about antitrust law. I think it's worth it to give a background of antitrust law in sports. Very brief. It's not going to be, a 40-minute introduction, but a brief introduction of antitrust law in sports. And then we'll talk about the age eligibility cases preceding Clarett, and then we'll get into Clarett. One thing that I ask of you today is, as I mentioned, to my right, we have two members of Maurice Clarett's legal team. I am a sports agent. So you have three people, and I'm going to try to be the voice of reason here on the side of the NFL and the NBA. But we have three people
that automatically disqualifies you.
We have three people who are, to put it bluntly, on Maurice Clarett's side. So all of you, I'm sure not all of you have that opinion, so please pose the questions. Don't be like the Boston media. Pose the hard questions, and we'll go from there. First, let's talk about the rules. Okay, the NFL rule. The actual rule says that you have to be 4 years removed from your high school class in order to qualify for the NFL draft. That's the actual rule. There's a special exemption which the commissioner regularly implements that allows 3 years removed from high school in order to be eligible for the draft. You have to apply in order to get that special exemption, but it's almost universally granted in that situation.
3 years removed from your high school graduation.
Right. Correct. You do not have, right. The class you were in high school having graduated, 3 years removed. Not you necessarily having graduated, but your class.
I mean, that's interesting because the rule actually says 3 years removed from your high school graduation. And, of course, that was not the rule they applied to the Pittsburgh athlete whose class graduated 3 years removed, but he himself had graduated a half year later.
Okay. I've already been corrected. We've been doing this for 3 minutes. Okay, great. The NBA rule, which is in the new collective bargaining agreement. It used to be, up until this collective bargaining agreement, that your high school class had to have finished high school, correct?
Right.
Okay. Now they've changed it. Now you have to be 19 plus 1 year removed from high school in order to be eligible for the NBA draft, and that's United States-born players. International players have to turn 19 during the calendar year of the particular draft. So we have two different rules. The NFL rule has been ruled on in Clarett, which we'll talk about in a bit. The NBA rule, new rule, has not been argued as of yet to a court. So what we're really going to be talking about a lot here is antitrust law, and that's the main challenges that have been issued to the age eligibility restrictions, that they are violations of the Sherman Act, particularly Section 1. And the components of Section 1 of the Sherman Act are three. There needs to be a contract combination or conspiracy. Number two, that contract combination or conspiracy has to produce a restraint of trade. And number three, that restraint has to affect trade or commerce among the several states. Now, in most areas, non-sports areas, we're talking about restraints on trade in the product market. But in sports, what we're really talking about, at least with age eligibility, is a restraint on trade in the labor market, i.e. the market for workers. Now, there are per se violations of antitrust law in other areas, non-sports areas, and we'll talk about that in a little bit, but the rule which governs the court's thinking generally is what's called the rule of reason, which was the rule handed down in the professional engineers case of the Supreme Court in 1978, which basically says an agreement is unlawful if the anti-competitive injury it causes outweighs the pro-competitive benefits it generates. Now, what we're talking about here, and it's very important, and I'm sure we'll get into this a lot later, is the economic competition here. It has to be, the pro-competitive benefits have to be on an economic level. You may have also heard of the least restrictive alternatives issue. Even if there's pro-competitive benefits, if there's less restrictive alternatives, the court's going to rule against it. Now, there are per se violations of antitrust law, but in sports, there aren't really anymore. And the courts really shy away from per se violations because in their minds, sports leagues are different. Smith versus Pro Football, which was a D.C. Court of Appeals case in 1978, which was one of the cases which really brought this into play. This was talking about the NFL draft at that time. And what the court said in that case is that the rookie draft is not, in fact, a group boycott. So there's no per se violation. And the reason is because NFL clubs, they're really a joint venture. They're not really competitors in the economic sense that we think about, with Company A and Company B both making widgets, having no affiliation with each other, and joining hands to, restrain trade. And the NFL, in this case, hadn't really acted to exclude competition. They have to agree on some rules to govern the venture, whether it be gambling rules, steroid rules, things like that. Now, in the one Supreme Court case that really dealt with this issue, many of you probably know, is the NCAA versus Board of Regents, which is a Supreme Court case in 1984. And in that case, the Supreme Court really said the same thing about the NCAA, that you can't apply a per se rule in that situation to the NCAA. And basically that is, now people realize that there are no per se violations of antitrust laws in the sports setting. One other thing as background, which the NFL used so eloquently to get out of the Clarett decision, is the labor exemption, which we're going to talk about extensively today. The Mackey case, which was an Eighth Circuit case in 1976, which I had an argument with a sports law professor at Boston University the other day who claimed that this case was overruled, which I vehemently said it was not, said that there are really three elements in order for the labor exemption to apply. And the restraint on the trade primarily has to affect only parties to the collective bargaining agreement at issue. The issue has to be a mandatory subject of collective bargaining, i.e. wages, hours, and other terms and conditions of employment. And it has to be a product of bona fide arm's length bargaining. This is what the leagues are using in Clarett, and if an NBA challenge is implemented, which it undoubtedly will, to get out of the rule of reason, because they know that they can't win if it gets to the rule of reason level. Clarett was not the first age eligibility case in professional sports. The Denver Rockets versus All-Pro Management was a California case in 1971. Mr. Haywood, at that time the NBA rule was 4 years removed from high school. Mr. Haywood challenged the rule. The court initially said they granted a preliminary injunction in his favor. They eventually issued summary judgment in his favor as well, saying the rule was an antitrust violation. Now, this was before NCAA, the Board of Regents case, excuse me, and the court said it was a per se violation in this situation because it was a group boycott. And they didn't even need to get to the rule of reason in that situation because there were no exceptions from the exclusion. There were no, there were no alternatives that the NBA gave. They didn't allow a case-by-case basis or anything like that. It was an absolute group boycott where you excluded from the NBA by age. Now, as we mentioned, the courts see things differently now, so you're not going to have a per se application. They're going to go to the rule of reason. But that's why the labor exemption is so important now, because these leagues can't really win. They can't win at the rule of reason. There were another two cases, the Linsman versus the World Hockey Association and Boris v. USFL, which basically applied Haywood and said the exact same thing, that there were, these age restrictions were group boycotts, which leads us to the wonderful case of Maurice Clarett. I think it's worth it to talk about the lower court case because that's probably the one you guys like to talk about more.
That was a good case. That was very, very well reasoned.
District Court, Southern District of New York, February 5th, 2004, is handed down. Judge Shira Scheinlin. So, now the background, if you all don't know who Maurice Clarett was, probably do.
This is Ohio.
It's not Columbus.
But his high school was right near here, right?
We have a TV audience as well. I need to go into it for that. That's right. Maurice Clarett, very good football player, to say the least. He won the NCAA championship with Ohio State in the 02-03 season. He was then declared ineligible for 03-04. I'll leave it at he was suspended by the NCAA and Ohio State. We don't need to get into the reasons for the suspension right now.
Well,
yes, we do.
The NCAA does not suspend anybody.
Okay.
The college must suspend the player, and then if the NCAA believes that the college has not dealt properly with the player, the NCAA then can take action against the college. So it was actually Ohio State that essentially told Maurice that he could not play with them that season.
Tarkanian situation, similar. Okay. So Maurice Clarett challenged the NFL age eligibility rule under the antitrust laws, saying it was an unreasonable restraint of trade. Now, the NFL came up with their defenses, and it was very important in the lower court decision because Judge Scheinlin got to the rule of reason in that decision. Now, the NFL defenses were very interesting. They basically said that what the age eligibility rule is, it excludes the individuals who are too immature to play football. It also protects clubs from players who are more susceptible to injury and the adverse financial consequences which would result from that. It also protects individuals from losing their college eligibility if they're not drafted, and it protects them from using steroids, which I thought was the most interesting argument that they made, because they said individuals who are younger and not as developed are more likely to take performance-enhancing drugs to speed up their athletic development.
Right.
So what the court said, the court addressed the labor exemption, and they did look to the Mackey test for guidance. And what Judge Scheinlin said was, she said there was no labor exemption because we're not talking about a mandatory subject of collective bargaining here. There's no references to wages, hours, or terms or conditions of employment at all. The exemption cannot bar Maurice Clarett. He was excluded from the bargaining unit. He was not part of the bargaining unit. And the rule existed pre-union and wasn't endorsed directly in the collective bargaining agreement, so there was no arm's-length bargaining. The NFL rule, unlike the NBA rule is now in the collective bargaining agreement. The NFL rule is not in the collective bargaining agreement, I believe, and correct me if I'm wrong. It was in the bylaws, which are incorporated in the collective bargaining agreement. It is no longer in the bylaws. It is now in a memorandum, which is incorporated in the bylaws, which is incorporated in the collective bargaining agreement.
That's correct.
Okay. So the court then addressed the rule of reason, and they did cite the Haywood case and other cases. And even though Haywood was decided prior to NCAA, so there was no per se approach. The analysis to Judge Shylin remained sound, and what they used in that case was a quick look inquiry. A little different than per se. It's an intermediate inquiry. They use it. They said they use that standard because the rule has anti-competitive effects which are so obvious, and they rejected the league's pro-competitive arguments because it had nothing to do with promoting, remember, economic competition in the labor market. And again, even if there were legitimate pro-competitive arguments, there were less restrictive alternatives. You could do things on a case-by-case basis. So they granted summary judgment in favor of Maurice Clarett and ordered that he be allowed in the NFL draft. And I have to mention my favorite line from the case, because Judge Shylin had to make an NFL reference when she said, "Because the NFL cannot prevail on any of these defenses, the rule must be sacked." Great line. So the appeal goes forward.
On an expedited basis.
Yes, on an expedited basis. May 24, 2004, Judge Sotomayor comes down and says, "You know what? You're absolutely wrong, Judge Shylin. Everything you said is a load of crap, and we're going forward, and we are going to make sure that Clarett does not play in this league." They said the eligibility rules were in the NFL Constitution and in the bylaws. They weren't in the collective bargaining agreement, but the collective bargaining agreement does incorporate those provisions through a waiver of the right of bargain on those issues and such. And the court did not regard the Mackey test as applicable. They said the labor exemption is, and that the NLRB, not the antitrust law, should govern. These were mandatory bargaining subjects. They're conditions for initial employment, and they have a tangible effect on wages and working conditions of the current NFL players. And the union agreed in the collective bargaining agreement to waive the challenge to the Constitution and the bylaws, so this has to be reserved for labor law. Good summary?
I think they in a very weak and very short portion of their opinion, went through those three Mackey factors. I think what the Second Circuit said, and Mike, you correct me, I think what they basically said was, we are not going to, the labor exemption is going to apply in any case in which someone from labor challenges an antitrust law, an antitrust violation. That they read Brown, which is another Supreme Court case, to mean that as long as there is a bargaining unit and as long as there is a collective bargaining agreement, even if the subject isn't part of that agreement, but as long as you have that context, we're not going to hear any cases where an employee challenges a rule.
And that goes to the idea that it's more form over substance, which is a proclamation that could be very dangerous in terms of unions and management negotiating. It sets incentives that can be deleterious to prospective employees. It can also create incentives for existing employees to pursue policies that aren't in their long-term best interest. So it's a very troublesome decision how expansive they interpreted it.
Yeah. I mean, the best example that I could give, which is what I tried to give to the Second Circuit, not that they were listening, but when the USFL broke up, one of the players, what happened is the players then were subject to an exceptional draft in the NFL. And one of the USFL players challenged that and said, I want to be a free agent. And the court said, no, under the labor exemption, the union and the league can agree that you're going to be subject to this draft. But suppose it was, what I said was, suppose it was something different. Suppose the NFL and the union decided, you know what, we really hated this USFL, and now that they've broken up, we are going to set a rule that says none of them can ever come into the league. And it's so obviously an antitrust violation. And yet, under the Second Circuit's reasoning, Clarett, it can't be challenged.
Yeah, they provided such a wide scope of autonomy that it prevents the law from acting as a safeguard.
Well, I guess, okay, so to start the questions in here, and remember, the two individuals to my right are advocates. So please, yourself be advocates as well. We do need some advocates on the NFL side here, and I will try to be one as well. what's the main problem with using the labor exemption as a defense here in the NFL's case? I mean, is the Second Circuit really wrong? I mean, we're really talking about mandatory subjects of collective bargaining here. This affects wages.
We're not. It doesn't affect wages.
Of course it affects wages, because it affects wages it affects everybody else in the league's wages when you don't allow certain people into the league.
No, it doesn't affect. That was one of the arguments they made. And the NFL says it affects people in the draft. Well, it doesn't. I mean, if there's going to be, I forgot how many people are in each draft. Maurice doesn't. All he replaces is the last person in the draft. The same amount of people are drafted. The same wage scale takes place for the first round, the second round, the third round. All that happens is, if Maurice happens to be a first-round pick, he gets first-round money. Nobody is excluded except the very last guy in there. So it doesn't affect wages. It's not a term of employment. It's not a condition of employment. And the court, totally misread that word, condition of employment. Condition of employment doesn't mean you can be employed if you are this. Condition of employment means, what's the locker room like, what is the field like, that kind of thing. So it's not a condition of employment. And Maurice is clearly, or any of these college athletes, are clearly outside of the bargaining unit. The whole rule is aimed at those who are not within the labor organization.
And they have no one at the table. So obviously the players have an interest in keeping the better players out because that's going to preserve their jobs. You have to begin to wonder who's looking out for the legal interest of prospective players when you have management and the union negotiating to their adverse interests.
But it does affect wages to the extent that Maurice Clarett's not the best example. I think Mike Williams is a better example because Maurice Clarett's not on the NFL roster right now, and Mike Williams is. Mike Williams was a wide receiver at USC. He wasn't involved in the appeal, but he was waiting to see what happened, essentially. And Mike Williams was a first-round draft pick this year.
Right.
Mike Williams would have been possibly the first pick overall in the draft. Possibly. Probably not, but possibly.
Third or fourth.
Okay, third or fourth pick. So that is going to affect the wages by bringing him into that system, regardless of the last pick of the draft. Yeah, you're moving everybody down one spot maybe, but by bringing him into the league, you are affecting the wages of another wide receiver on that roster. So even though, on the Detroit Lions roster, now that he is, so one wide receiver is going to get cut, and his wages are going to be affected because Mike Williams is now on that roster, so the wages are affected.
The aggregate wages aren't.
The aggregate wages.
The individual wages are just wages. It doesn't say aggregate wages. It says wages.
But typically, antitrust law hasn't been applied to protect the interests of one employee, and that's what it would be in that case. They look at the broader scope of who's being affected. They look at the patterns, and to have the fifth wide receiver who's lucky to be on a team be the person who's hurt, that's unlikely to trigger an antitrust suit.
Well, we're not talking necessarily about a fifth wide receiver who's unlikely to be on a team because we all know how the NFL works. But when Mike Williams came to the Detroit Lions, who was released? I can't even pronounce his name. Zakir Hakeem, who's a good wide receiver who's now in the New Orleans Saints, and his wages were affected. So the NFL works. They're going to keep that fifth receiver because he's going to be the guy on the practice squad or the guy who's going to be on the special teams unit who's making $100,000 a year, and they're going to get rid of Hakeem, who's making $1 million a year, and now he's got to go to the Saints, and he's making $400,000 a year. So his wages are affected.
In that instance, but if he were good, he wouldn't have been cut. I mean, it goes to the idea that they're letting go of the player who they least wanted to keep. And at the end of the day, that's an employee that typically doesn't have tremendous rights under antitrust law.
Yeah, it's no rights. I mean, the player who says, I just want to be in the NFL and I don't like this draft, that's a clear loser under this case. The player who was just not picked, he doesn't have an antitrust violation. I mean, he can't claim an antitrust violation. He's lost in the competition, in the normal competition of the draft. That's not what happened with Maurice. Maurice wasn't allowed to compete. So, I know you don't even believe that it affects wages. But
No. Well, here's okay. The next question. You want to keep going? Okay.
Well, let's go to the real. I think the really essential topic underneath all of what happened here, and that is, why is there an eligibility rule in the NFL and the NBA and nowhere else? It's not in, obviously, tennis. It's not in golf. It's not in hockey. You know, when the NFL said that we did it to protect the players. I mean, everybody knows compared to hockey, the NFL is like a game of tennis.
How about boxing? You can be 18 and box. You can get punched in the head repeatedly. You can punch someone else in the head. You're mature enough to do that, but you're not mature enough to catch a pass out of the backfield or dunk a basketball and cash a paycheck at the same time.
Right. And the other analogy I gave to the court was, suppose you had a kicker in high school who could kick 65-yard field goals. Tell me why he can't go from high school to the pros. Who are you protecting other than what? What do you think the reason is? Why only basketball? What do basketball and football have in common? What?
NCAA.
That's it. They are the money-making sports of this cartel called the NCAA, which, in my view, since the fall of the Soviet Union, is the most dictatorial regime left on the planet. And the entire basis of these eligibility rules is to perpetuate that system where players who are otherwise eligible to make money and earn a living are forced to work for nothing. And not only work for nothing, but risk career-ending injuries where they will never earn anything and nobody will take care of them.
Are you advocating the same thing like baseball has, where you're going to have minor leagues for football and basketball players? Because obviously somebody has to develop football and basketball players. Baseball does their own development. Are you saying then that there should be minor leagues for basketball and football?
Well, I mean, I think it's up to the NFL and the NBA, but the fact that there are no minor leagues, the minor leagues are the NCAA.
That's correct.
And they're trying in basketball. They're trying. With the NBDL now, they're trying.
And they're trying, supposedly, with the WFL,
Right.
If you allowed, we're just talking about such a few amount of players from the NFL who would make it from high school into college, or perhaps after first year into college, or perhaps after second year. We're talking about just a small number. So I don't think you have to have a minor league in order to perpetuate this system. But the point is, it's this conspiracy between the NCAA and the NFL and now the NBA to perpetuate this, what we call a plantation system, where you force these players, particularly in basketball and in who does it affect? It largely affects, I think, what the professor was saying in the beginning, which is, we have these middle or upper class white people who want their children to go and get a good education rather than pursue a career in sports right away. Well, that's all great. That's all great. But if you have a kid who grew up in the ghetto, doesn't have a father, whose mother is living on welfare, has no money, who the kid has no money, who was forced in this hypocritical NCAA system to take money from alumni and feel like he's a criminal just to live like any of the other students. How can you possibly justify saying when he is able to earn a living that he can't? It's just an outrage to me.
Right.
What are your thoughts then on having colleges pay draft?
I think it's an impossible situation to have colleges pay athletes. But those who are in college should be able to make deals with Nike and do everything else, get deals so that if their image is sold on the shirts, that they make money. And the Clarett jersey, they sold more number 13 jerseys with Ohio State on it than they ever did for the history of any other player. He doesn't get $1 out of that. Why not?
And if Michelle Wee is mature enough at 16 to enter those same endorsement deals, why isn't Maurice Clarett at 20 or 21 or 19 able to do the same? What's the difference?
The problem with outright paying college athletes, I think, is just in how you would do it. I mean, we talked about it a little last night at our dinner, and who gets paid? Is it just the money-making teams? Is it, the football teams and the basketball teams are generally the only teams at any college who make money. And that money supports the other teams at those universities. So should just the football players and basketball players get paid? That would never work with Title IX or just anything. So the problem comes in, then you start playing every athlete, every softball player, every gymnast, everything, and that's just not something that the NCAA is going to go for. But these programs cost a lot of money. I mean, right now in Ohio, the state of Ohio, there's 2 professional football teams: the Cincinnati Bengals and the Ohio State Buckeyes. The Browns are still in the minor league. You remember we are in Cleveland, right?
No, just to jumpstart this, I want to interject one thing. We really do want to have this be an interactive day and everybody participate as much as possible. So don't hold back. We're trying to, Joe has a list of questions he's going to go through. We want to make this a little different from most CLE presentations, as those of you who've taken my course know. You're going to teach us as much about this as we ourselves know. So, as an incentive for the best question, the most insightful question, we have free tickets. 2 free tickets to the upcoming exhibition at the Gun, where the Williams sisters are going to be on tour, Venus versus Serena, courtesy of IMG, and you're going to collect your tickets from Chris Callahan. One of our panelists, his brother Kevin, has been kind enough to donate these 2 free tickets. So I sense a little bit of shyness here, reticence, and Alan, if Alan would only tell us what he really thinks. But it's not as if he has no offense, one court didn't think he had a monopoly on wisdom here. So, feel free.
No question about that.
And I would say, let's just throw another log in the fire to get ahead with the baseball panel. How come Drew Henson or somebody like that can go ahead and get paid to play minor league baseball and still maintain his eligibility in football? For Michigan. And why does that go to your point? Does that make your point, or
let me answer that one? The reason that Drew Henson, I know that's going to be discussed later on, so I don't want to get into it too much here, but the reason Drew Henson or Quincy Carter or Ricky Williams can go play baseball in the minor leagues for however long they want, and then they can come back and have their eligibility for college football is because the NCAA has decided that that's what they can do. That's really the answer. You are allowed to go play another sport professionally and then go have your eligibility in another sport. What you can't do in the Jeremy Bloom situation, which I'm not going to talk about because I know that will be talked about extensively later, is you can't go get endorsement deals. You can't go get endorsement deals because the NCAA has determined that they have no idea what those endorsement deals are for. Jeremy Bloom was a skier and a football player. His endorsements were for skiing generally, but the NCAA said you can't determine that the endorsement deals are for skiing and not for football. So that's really, that answers, I think, that question. But, you're right. The NCAA would have to change. What Alan's talking about is just changing the rules to allow endorsements generally. But you're right. The fall of the Soviet Union couldn't have come, at a more opportune time, and they're not going to change those rules anytime soon.
Yeah. But there is no other field of endeavor where age determines whether or not you can earn your living. The Olsen twins can earn millions and millions of dollars, and then they can go to NYU and participate in the college drama program. Some violinists can play with the New York Philharmonic and make money, and then go play in the college orchestra.
And also, ask what age is. Age is a proxy, right? Age is a proxy. It tells us certain things about other people. It doesn't tell us specific things about those persons, but it tells assumptions that we have. Why do we have an 18-year-old floor for voting? It's because we assume that persons under the age of 18 are not mature enough, and those over the age 18 are. But certainly, we all know instances of people who are younger than 18 who are more than precocious enough to place a ballot, and we all know persons who are older than 18 who shouldn't be voting. But the difference with sports is that they already have this information telling them which persons at which age should be drafted. There's no mystery when teams conduct exhaustive evaluations, both on the field and cognitive evaluations, to determine whether or not a player can be drafted. It's not about age. It's about others' ability to measure his talent. We've seen that in the NBA with a countless list of college juniors and seniors who were drafted who ended up playing horribly in the NBA. Rafael Araujo, Trajan Langdon, who many of you may remember, Ed O'Bannon, Mateen Cleaves, Marcus Banks on the Celtics. It's not about age. These players were old. These players were 21, 22 years old. They had played 3 or 4 years of college, but they were poor. Yet we've seen high school players go right to the NBA, not just LeBron James, but there have been others, Amari Stoudemire, even Tyson Chandler, who was one of the best rebounders in the NBA last year. It's not about age. It's about talent. And these teams expend vast resources trying to figure it out, and they tend to be more right with the younger players than with the older players.
And I think you also have to understand why it is, and this is why it's an antitrust violation, why it is you have the rule. You have the league setting the rule. Why do they do that? Because the individual teams, without the rule, would draft the young player. So the coaches and the scouts have already determined, based on all the criteria that they use, that this particular player is good enough to play on my team, is good enough to make a lot of money. And they want to draft that player.
That's why a proxy belies the whole system. It doesn't make sense if you're going to conduct all of these exhaustive pre-draft evaluations of everyone, and then you're going to create an arbitrary floor. It doesn't make any sense.
Questions? I have a question. Good. Oh, good. We have lots of questions. Good. Great. Please, right ahead.
One of the things that I thought handicapped you in representing Clarett, being a criminal lawyer, he was regarded as a snitch. You know, and what he said got a whole lot of people in trouble, including the university. And that would be, of course, a difficulty that you would have to overcome. Now, my question to you is, as I try to do with my clients, I try to take them to the theater before they get on the stand. You know, don't say this, don't do this. And if you do say it, I'll kill you. Did you have that conversation with Maurice before he did some of these things? Now, we were very sympathetic about what you were talking about, coming from the hood and whatnot. But when he began to tell some of these deals that he got, the coach did this for him, and put the whole university on some kind of disciplinary thing, don't you think that that also caused some animosity in the arena that you were presenting him in?
Well,
Way ahead on points for best question.
when he's disclosed what he did about Ohio State, that was after we had already lost at the Second Circuit. He did not. One of the things that got him in trouble in the first place with the NCAA is that he wanted to protect his coach during the initial NCAA investigation. And so he wasn't as candid as perhaps he should have been when asked by, and I was in one of those sessions where the NCAA questioned Maurice. And Maurice at times was, of course, his own worst enemy. I mean, he's a very intelligent young man who just can't take the hypocrisy and doesn't deal with it well. And I think I said this last night to the group. Everything started with Maurice back at the NCAA championship, when, if you remember the story, a friend of Maurice's from high school was killed, and Maurice's mother had a conversation with the coach and with the athletic director, and they said, when Maurice goes with the team out to California, we will fly him back for the funeral. So the team went to California, and it came time to come to the funeral, and they said no. And the excuse that they gave is, we can't pay for the flight. And Maurice publicly, before the NCAA championship game, said, this is outrageous. these people don't understand there's something more important in life than football. And to say that in the context of an Ohio State football player getting ready to play for the national championship, and that was as sacrilegious as you can be. And after that is when the world started going downhill for Maurice. And the NCAA went after him, and the school went after him, and the New York Times went after him. And, you know, was he the best? Was he absolutely the best image to have? I mean, when you're standing before the Second Circuit, and you know that they think this guy is a spoiled brat, they want to teach him a lesson, and that was basically the thrust of their questions. I mean, they want to teach this kid a lesson. Well, yeah, but that's not what the case is about. The case is about the teams wanted to draft Maurice. They wanted to pay him a lot of money to play football, and there was this artificial rule that said, no, you can't do that.
You're entitled to a reply question here. And isn't it, why didn't he bury the school when he was given the chance, right?
You asked your question.
Yeah. we talked ahead of time. Why was he silent? Go ahead, you ask. Why was he silent when he could have buried the school? Go ahead.
Did you advise him to do just what he had?
Here you go, you win.
Well, I mean, I'm not going to disclose attorney-client privilege, but I can say this. Maurice
I don't
was
know anything about that after 53 years in the bar.
Maurice was not. You know, there are clients that you can control, and there are clients that you can't. Maurice was his own person, and you know he was determined to go his own way. You know, but that was one of the things that impressed Jim Brown so much about Maurice, is that I mean, this was a young man who was, you know, just very articulate and just unwilling to take the hypocrisy of the NCAA. Now, you know, the things that went on at Ohio State were just unbelievable. I mean, but it's actually not unbelievable. Like, you could all expect that what goes on at a school like Ohio State goes on. And everybody turns a blind eye. But if the player happens to do anything that's wrong, then the NCAA comes down harshly. And it's just an absolutely outrageous system.
Do you feel that's discrimination?
I mean, I believe that the NCAA is a racist organization, and that African American. I mean, this is an organization where which has what 8 African American coaches in the country. In football, 8. It's an organization that allowed up until the early 70s Southern schools not to have any black players on their teams. Didn't do anything. They sanction a team now because a coach pays for the kid to go to a funeral. They did nothing to a school like Alabama, which refused to have a black player on a squad until 1972. I mean, how's that?
Would be provocative, but Alan is making some really good points. Does anybody want to take the counter on your panel, Joe, or otherwise?
Come on, there has to be some management types out here. Okay.
I just have a question in reference to the things that you're pointing out that the NCAA has done that are negative and that are racial, but Clarett's situation is a totally different situation, and I think that image that's portrayed across the country educationally is that the NCAA, with this student-athletes program, is providing an education that people can be successful for outside of the sports that is totally overwhelming over what lawyers or the system can make off of those people. And when you start using that as a prototype, what about the story of maybe he couldn't tell all the things that happened with Ohio State because it started when he was in high school? I mean, you know, everybody looks at LeBron, but how many NCAA violations did LeBron make where he had no choice but to go to the NBA because people were taking care of him and his mother and his father in the penitentiary, all of these people, all the way from jump. You said people recruiting at 7, 8, 9, 10, 11. Football is so dangerous. Do you know if Maurice Clarett could actually make it through the 4 years? And you made that point earlier. Some people never make it.
Well, right.
At Ohio State, I think it was it's 18%. I think at Ohio
One
State.
injury that he had in high school was an injury that was supposedly he shouldn't be able to make it through 4 years of college. So that instant, I got to get into the NBA or I got to get into the NFL. Some of these players are put in that position when, in essence, if you have a high school student or a junior high school or middle school student, you want to just get them to understand that that is not necessarily the direction you want to go. Education is important. That's first. These systems will take advantage of you and use you. We don't tell them that. You're talking about the NCAA. There's a number of programs where they're trying to get minority management jobs. You can write for grants that can get you a minority position as an athletic director, assistant athletic director. They have programs like NYSP that actually funds programs for people in the community. Case Western Reserve has NYSP. Cleveland State has NYSP. There's a lot of things that are positive, but when you have so much power and so much money, the Cleveland Browns, or if you say the Cincinnati Bengals and Ohio State, how many people are caught up in that system and they're doing well from it, but the image that's portrayed from it is so a high school kid, all of them want to rap, or they want to play football, or they want to play basketball. You know, when you look at Clarett's situation, he was desperate. If you look at LeBron's situation, his daddy's in the penitentiary. He had to make decisions for his mother to make things happen. I think as lawyers or people who understand the law, and you start thinking about, okay, the NFL, Clarett and some of those people, if you've ever been on the field on an NFL game, their people are trying to kill them in their career. Every play. NFL, NBA, that's not golf where you're hitting a ball. Those are different careers. And sometimes we don't think about how we can protect those people. And a lot of times when you say a kid is ready to have this type of management, money, skills, any of those things, they're not prepared. And sometimes it might take a little bit more time to try to help develop them and let them see that this is a possible potential way that I can be better if I go through some of these systems, whether they make $1 billion or not playing football, or they make it as a businessman, or they make it as a lawyer. This was a football player, you know. He didn't have the skills. Like you said, he can't kick a ball 60 yards in high school. I saw a kid that was 6 years old kicking the ball 30 yards, 20 yards this past weekend in Southern Illinois. So he should be ready to go to college or go to pro. No. It's a developmental part that all of us as the upper echelons of intellect should start taking into consideration that these images the kids are seeing, and we're losing all of the content areas for everything with OGT, the type of testing. People are just focused on, I want to be up here with the pros. I want to be a pro. And we're losing all of that character that our society is supposed to be trying to nurture and develop. And sometimes as we make these decisions, you know, my question is, as you beat up on the NCAA, and you look at the NAACP and you look at affirmative action and all these things that are out there, are we really helping those kids as an agent or as a group of lawyers when we say, you know, can you take care of these things? Like he said, do you prep them? Are you prepping them before it's time?
Can I jump in?
No, we've made a big mistake here because we didn't invite you to be on the panel. Those are really provocative, really important points, and I just have to, for those of you who weren't at the beginning, I mean, that's the point I was making, to be provocative. You know, is get that education if you can. It's the old break a leg test. And Arnold Palmer will say, just to jump to golf, and say, well, you know, I could have played pro right out of high school, but I went to Wake Forest, and you know why? Because I wanted to avoid that Arrested Development thing, and those were the most fun years of my life when I was making those bonds with my college teammate buddies. I know it's golf, not team sports, but he said, you know, that's how I learned to be a businessman. That's how I learned when I couldn't play golf anymore to make even more off the course than I was able to make on the course. So that's the point I was trying to make to be provocative, is the education is the thing. If you get it paid for, you know, that's it for life. You can never play your sport again.
Can I jump in? I think you've identified the right aspiration. I don't disagree that education is, as a general matter, the right ambition for all persons. But if we look at the student athlete in the NCAA, we wonder why of the 65 teams that participated in the March Madness tournament this year, did 42 of them fail to graduate even half of their players? Why does the average Division I athlete spend between 40 and 50 hours a week lifting weights, traveling, attending team meetings, playing games, practicing, whereas all the other college students can only work at most often 20 hours a week. Why is there such a discrepancy? Why are they treated so differently? Moreover, why is it that when a college athlete gets in trouble with the law, nothing happens? Yet when his classmate gets in trouble, there's a sanction. What kind of message does that send when players on college teams consistently get in trouble and the coach looks the other way? That sends the wrong message. And in terms of injury, if at least in basketball we've seen over the last 11 years, players going directly from high school to the NBA, they're not more injured than they would be in college. There's no statistical evidence to support that. The data doesn't confirm. I don't disagree with your aspiration, but if we look at the realities of what's going on in college, it doesn't appear to be the environment that would enable the persons to get what you're searching for.
I think that's a good point, that they're treated, sports people are treated differently. LeBron is a perfect example of a lot of things, because LeBron was somebody who in 6th and 7th and 8th grade, everybody knew this kid was going to be an NBA star. Now, if he was in 8th grade and he was a superb violinist, his parents could find a special tutor who would do nothing but train him in the violin. You can't do that for basketball. They can't go if someone goes out and hires a trainer, a professional trainer for the 8th grader, he's going to lose his eligibility. Why? What makes the athlete different?
But they're doing that.
Yeah. But they're doing it in a system where they feel like criminals.
Everyone is doing it.
Well, not everyone.
It's soccer. Soccer has more scenarios where they have people personally training through their coaching than any sport that I've seen in Ohio. I coach at the Division III level at Oberlin College. I'm seeing a competition. Everyone's doing things, but they're learning how to work within the laws. You say that certain teams, high school teams, what's the difference between Glenville and what's the difference between East Tech? What's the difference between Shaker Heights and the difference between Maple Heights? There are people who are funding these programs where they have equipment, they have opportunities, they go to camps and they get special training. University of Kentucky has some people who can come in for $25 a day and try out to get a scholarship. Other people are going to pay $275 a day, or a week, or 3 days, or 4 days. Ohio State has 5 weeks of camp. There's all types of special training that's going on. Some people are charging $20 to give you 1 hour of a session. You have the strength. There's a company that's in Euclid that trains Gerald Vicious. And he has people come in there, and it's all type of deals that are set up for kids to come in and to get all types of things that's going to make them great. Enhanced performance.
And that's our lunch speaker, one of whom is up top there, Kevin O'Donnell.
I know Kevin.
Yeah.
We go back.
The bigger, faster, stronger camps is what we're talking about. It starts in the 5th, 6th, 7th grade, right?
I mean, little kids. I talk to personal trainers in California, and there's people paying money for that, yes. But it's also other opportunities for children to actually go out, and the media is so good. The internet is so good. I don't know many kids who play football that's not on some type of performance enhancement. All of them are taking some type of performance enhancement. The milkshakes, all of them have it. It's not that much. We're talking $30 a month. Cell phones are $45 a month.
But if you banned, let's say you banned that you had to go play 4 years of college before you can go to the pro sports, wouldn't those persons still have similar incentives to pursue the best college scholarships? Doesn't the situation of what they're in terms of, look, if I want to go play at Notre Dame or I want to go play at USC, I need to bulk up, I need to do all of these things. So I don't even know if you have an age floor that you eliminate those incentives.
If you go to Purdue, if you go to Ohio State, you don't really have time to do the educational tip unless you just are a special person.
Right.
That's true.
Right.
I understand that. My son is an athlete. He's been at Purdue and is at Youngstown State right now. There's so much politics that's played in that, but as a parent and a coach and working at the Division III level, we still have to teach people the right way. And I have to tell him and I have to tell other young people, You still have to get your education and understand that if you perform at the right level, and Kevin will probably say it, the Europeans, they expect maturity at middle age, older, don't they? Some runners and sprinters have done a little bit better after they've been properly trained at older ages than what we do in America. We'll take a younger person and say that you're mature and you're ready to go.
But I actually studied among NBA players arrest propensity and how long players who have been arrested in the NBA, how long they played in college and how old they were when they were arrested. I actually found a near inverse relationship between number of years spent in college and propensity to be arrested among NBA players. So in other words, it goes against what we're typically accustomed to. And I suspect a lot of that has to do with the environment in which these players play in college, the kind of messages that they see. We just saw Tony Allen arrested on the Boston Celtics. He was alleged to be in a shooting. You begin to wonder what happened in college. And you go look at his college record, and you see that he played for 3 schools. You see that he got in trouble, yet there was never any sanction. You see this pattern again and again and again. And you begin to wonder, what's going on when they're in college? What kind of mentors do they have? Would they be better off in the pros when they have a 30-year-old mentor helping them than a 21-year-old mentor? I'm not saying we have conclusions on these, but I think these are open-ended questions.
There's a question from upstairs, which thank you for being there, wherever you are, and it goes to the NBA rule, which you're an expert on, Mike. It was just changed, as we've talked about. Would a challenge to the new, current NBA eligibility rule be successful in light of Clarett? Well, would you take that case, is my question.
I would certainly look at it.
I think you referred to me.
I think I'd refer to Allen, right.
Okay.
And then Allen would hire me.
But maybe we state what the new rule is and what the challenge might be.
Sure, do you want to restate?
Sure. The new rule, I mean, it used to be 1 year. It used to be your high school class having graduated. They've since changed it in the new collective bargaining agreement. You have to be 19 years old and 1 year removed from high school. So that's the new rule. And actually, that was a question, Mike, that I was going to pose as well. And even to add on to that, if you were going to take that case, Alan and or Mike, I assume you would probably stay away from the Second Circuit.
Yeah, you'd lose in the Second Circuit. Right. You would lose in the Second Circuit, but you'd file it. The ideal case would be to file it in the Sixth Circuit.
Okay.
And remember, Clarett had a hypothetical, right? Clarett had to argue, Susie, that if we change the rule, this is how the NFL will be. With the NBA, we've already seen 11 years of data. We've seen that the average high school player in the NBA averages more points, grabs more rebounds, and dishes out more assists than does the average NBA player or the average player of any age group within the NBA. In other words, high school players that matriculated directly from high school to the NBA have been the optimal group. And there is no way a court will overlook that. We have actual evidence. We're not arguing a hypothetical. We're arguing past precedent.
Well, I mean, the Second Circuit would overlook it because
you
don't get to the antitrust. You don't get to the antitrust issues at all unless you get past the labor exemption. So in the Second Circuit, unfortunately, a challenge to the NBA rule is going to, I think, lose under the labor exemption.
But other circuits,
right.
we think we.
Yeah, I think the Sixth Circuit. I think that case is winnable in the Sixth Circuit. Now, of course, the difference between the NBA and the NFL Clarett case, I mean, there was no way in the world any court could find that the rule in the NFL was collectively bargained for. Of course, the Second Circuit found that. But, I mean, it was just an impossible situation to even imagine a court to conclude that this was collectively bargained for. Now, the NBA rule is in the collective bargaining agreement, so you're going to have that additional hurdle. And the only way you win is to say, again, it's not wages, it's not hours, it's not terms of employment. And 2, it primarily affects those outside the bargaining unit. Indeed, it's aimed at those outside of the bargaining unit. I mean, again, look at the reason for the rules. One is to perpetuate the NCAA system. The second is, and this is, I think, the NBA's reasoning, when they had a Kwame Brown who missed, who was the number 1 pick in the draft, when they miss, it costs them a lot of money. And so they believe that if they get another year where they can look at these players, that their scouts can then get more data and have a better feel for whether this guy is a sure thing or not a sure thing. Now, when you understand that that is the reasoning behind it, now you look back at a Kwame Brown. who signed a lucrative NBA contract right out of high school. If he had gone to college, if he had been forced to go to college, and let's say he did as poorly in college in basketball as he did in the NBA, then he wouldn't have been drafted. So he never would have had the opportunity to make the money he made out of high school and let the NBA team, the Washington basketball team, let it be their error and their risk and their loss as opposed to his loss. And I think, our system is structured ideally so that if the employer makes a bad decision, that's his fault. It shouldn't be on a Kwame Brown who excels in high school to the point that the NBA teams are willing to pick him number one in the draft. And then if it doesn't work out, he's still got his money, and now he can go, you talk about education. There's nothing to keep a Kwame Brown if he gets out of basketball from going to college. I mean, that's what's so laughable about this academic argument. In any other field, I mean, the Olsen twins are at NYU. They've made millions of dollars. There's nothing to keep anybody from going to college with a lot of money in their pocket. Why do you think that if you go early and get money, that somehow you are foreclosed from ever enjoying the wonders of an academic environment? It's just ludicrous. Believe me, there are some rich people at Case Western, rich students. They got a lot of money in their pocket, and they sit in their class and they learn. You can learn with a full wallet. I promise you that.
We have a question up here. One point I do want to make, though, with the NBA, the reason the NBA is a little different is I think the assumption is that with this 1 year change, with that everybody is going to go to college now for 1 year because that's their only recourse. Well, that's not exactly true. I guarantee you, in the next year or two, you will see whether it's the Sonny Vaccaros of the world or some startup enterprise. You will see some league or some touring company come out that's going to take the O.J. Mayos of the world and the LeBron James when he was in high school and take them and pay them a certain amount of money, get them a shoe contract, go touring across Europe or touring across the United States, and there will be some new basketball league out there that will take advantage of this. So I don't know what we're doing by the NBA, but the NBA is actually making these guys go to college.
Example of the person coming in as a freshman or he's a child prodigy. I'm more concerned with the person who's availed themselves of the system up through his junior year. Now we're going to play for a championship possibly next year. The team has come to fruition, and now he's going to jump. He's a key man in the team makeup, and he has the considerations of the university and of his fellow students or fellow players. And I don't think your situation addresses those two interests.
So you think if the kid who's got
he was Clarett, right. He was a junior, wasn't he? And
he only played 1 year.
Right.
That's the Matt Leinart case. That's what you're talking about. He decided to stay, gave up maybe 60, 65.
So you think there should be an obligation on the part of these kids who perhaps come from poor environments and have no money and their parents have no money, but they should stay an extra year in college so that their college team has a chance to win the championship.
And the benefit of the university. That's back.
The financial benefit, certainly.
The university.
Right.
It's what Leinart did, right?
And that was his choice. He made a decision. He had the opportunity to make a decision. And what we would argue is that there should be the opportunity to make a decision, that you should be able to decide, I have a very limited window of time in my life when I can make a lot of money and I can rectify arguably centuries of poverty in my family, and I don't want to risk it by staying another year in school and blowing out my knee or not playing well, particularly when I have an opportunity to go to the pros right now. Why should I take that risk? And the loyalty factor is something that some players may value a lot, some players may not value a lot, just like all of us, right? We all work at jobs. All of us have different values and loyalty. All of us have different opportunities to change jobs. All of us have all these different opportunities. Should we be foreclosed from changing a position because of something called loyalty? Maybe we'll weigh it, but we have the right. We're not under a contract, unless we are. And certainly a player is not under a contract because he's not earning anything in college.
And Maurice Clarett did bring Ohio State a national championship. I mean, wasn't that enough? I mean, he brought up one national championship. He ran down the field when that guy intercepted the ball and ran down the field and knocked the ball out of the hands of that runner, got the ball back for Ohio State, and let them come back and win that championship. That should have been enough. Diana, as we say. That should have been sufficient.
Well, we're discussing the pinnacle of professional sports, but what's to prevent these players from going to international basketball leagues and Canadian Football League or Arena Football Leagues? I mean, we are discussing that the NCAA may be taking advantage of these athletes, but what's preventing them from going to other leagues since there are these age limit requirements? Versus minor league baseball and minor league hockey, these are the only two professional sports leagues that don't have minor league systems. But there are other leagues that they can choose to go to play professional sports.
Money.
Well, that was one of the arguments that the NFL made, which is we're not a monopoly because look at the CFL and the WFL. I mean, come on.
And also, but the basketball argument
you make
is
$200,000 a year in the CFL, and that's somehow on a par with the NFL. I mean,
But it's an avenue to get to the NFL. Much like international prospects have stopped coming to colleges to play basketball.
Well, why shouldn't you be able to go right to the NFL? Why not?
Why should you risk an injury? I mean, it would be like if you can go to a firm in Cleveland and make $100,000 a year. Just take an arbitrary figure. Yet there's a rule that says you can't do that. You're going to have to go to Bulgaria to practice law for a year, and you're going to make $800. They're going to say, well, look, you can still practice law. You're still going to earn income. Is the proportionality of it? Is that it's completely unfair?
The problem
and it's the risk of injury.
And there's a risk of
The problem is that the NFL is the only legitimate football league in the world. The NBA, the argument is a little different because you do have the overseas leagues, so it's a little different, but you're still making a lot less money overseas. Even the best players are making a lot less money overseas than they are in the U.S. Now, the reason is money. I mean, that's the reason. But you may see, as I mentioned, you may see these leagues or teams, traveling teams pop up because at this point, that's the only avenue they have. They can't play in the NBA when they're 18, so they've got to go play in Bulgaria. Bulgaria's a bad example because they don't pay that much, but Spain or Italy. So they might go over there. Turkey pays well too, right? So they might go over there and play well.
But are we helping the person by forcing him to do that? We have an 18-year-old who his family would probably prefer that he stay in the United States. Yet now we're going to have to export him to another country so that he can do what he wants to do. I don't see how that's in his best interest. I don't see that's in his family's best interest. I don't know. I mean, I certainly see that maybe the pro leagues would like to see development of them not paying, just like with the NCAA, but I don't see how he's much better off.
Let's take this question right here.
I think it's obvious the panel doesn't like the status quo of the system, let's say, in the NFL. But what system would you implement if it's believed and there is the perception that part of this is to protect, not necessarily LeBron James, who's going to make it, say, in the NBA, or Maurice Clarett or Mike Williams, but those kids that think that they've got the talent, don't get drafted, and then don't have that education to fall back on. Or as you said, it's a proxy for maturity, and they get into the pro game, whatever that game might be, when they are immature, and they become a train wreck, let's say like a Jennifer Capriati. What system would you implement to try and protect that group of players, to try and protect that person so that they both get their opportunity, but by the same token, they don't wind up in that situation where, because they didn't grow up to handle all that money, handle all that fame, and they wind up either never making it in the league or go and spend years, as I said, as a sort of a train wreck like Jennifer Capriati.
I don't think you don't have to develop any system. There's no system that you need that's going to help the kid who comes out of high school or first or second year of college that you don't already need for the kid who goes through 4 years. I mean, whatever you think happens or potentially happens is no more likely to happen to the high school kid who jumps to the NBA than it is for the guy who's going through 3 years. I mean, the statistics just don't bear you out. Mike has done that research. The high school athlete to the NBA is more successful, by and large, than the athlete who's going through 2, 3, 4 years of college.
Moreover, we've seen...
What?
Marvin Barnes proves that. There's a lot of He was always a thug and always will be a thug.
How about Latrell Sprewell? He choked his coach at age 28, and he played 4 years of college. I mean, at some point, Ron Artest, 2 years of college. And Ruben Patterson, 4 years of college.
And I'm from Philadelphia. I mean, Terrell Owens isn't,
There's always going to be thugs. And it doesn't matter if they have 4 years of college or 1 day of college or whatever. Then they're people that have gone through college, have gone through good programs like Michigan, and then they rob banks because they couldn't make it in pro sports. So they obviously had a problem, and it doesn't matter if they lived in the hood or a suburban environment. Some people are, if you want to have a criminal aspect to their character, and it doesn't matter how much education they have or how little they have, they're still going to fall back if they can't make it one way and trying to do it illegally another way.
Question. I had a general and a specific question. Generally, given that the players in the NFL have voted to be represented exclusively by a union, and given that the union spends all of their day and night thinking about what's best for players, don't you think that a union and the group representing the management are well situated to determine whether there ought to be an eligibility rule with an age aspect? And then the specific question is, do you think Maurice Clarett would have been better off coming into the NFL a year before he did? And if so, what happened?
No question about that. You mean had we not lost the Second Circuit and had he gone the year before?
What was it about the year out that undid him? Because he said he was in better shape, and the like, and he felt like he was more mature, and he crashed and burned this year. I'm just wondering.
He did crash and burn.
He also went to the combine and performed terribly. I mean, that's really what it came down to.
But he felt like
I think it would have been. I think he would have, if he had been drafted that first year. My personal view is I think he would have been a star. Maybe I'm biased. I probably am, but I think he would have been a star. I still think Maurice is a tremendous talent and has a chance to make it in the NFL, and I hope he does. As to your other question, there's, of course, the labor organization and the league can decide on an age eligibility rule. But the labor exemption says that doesn't make it exempt from the antitrust laws. That's an antitrust violation. Suppose the labor organization and the league decide, you know what, we don't want anybody to endorse Nike products. They can't do it. I mean, they're a labor organization. You've got the league. They probably have pretty good reason for deciding that, but they're not allowed to. I mean, the antitrust laws are supposed to be a fairly strong measure to promote competition.
Okay. But there's an interplay between the two bodies of law. So do you just disagree that this ought to be recognized as something that's covered by a labor exemption?
I don't believe that age eligibility should be covered by the labor exemption because it primarily affects workers outside of the bargaining unit. And that's, it's an exemption to the antitrust laws. It's supposed to be narrowly construed.
But in the example of the NBA, you talked about Kwame Brown that doesn't work. Isn't it in the players' interest and management's interest for their draft to work as well as it can? It's designed to have the poorer teams draft higher. So if the players' union and management believes this will make a better draft, if we draft players later, we're less likely to make mistakes. And if a team drafting high makes a mistake, then they continue to be a poor team, and that's bad for the league generally and bad for all the players in the league. I mean, do you think that the people that spend the most time dealing with players' interests and management's interests ought to be able to make this kind of rule?
I don't believe they should be able to make a rule that stifles competition, even if it's in their best interest to do so.
How about salary. If you're in the league for 4 years, you have to make $400,000. But there are probably players that have been in the league for
They can do that.
number of years.
They can do that. That only affects players in the league. It affects wages, and it's bargained for. So it meets that narrow exemption.
But it does keep some players out of the league because the team may think, you know what, you're not worth $400,000, so we can't hire you for less than that.
But it fits the three criteria. It's not the same as keeping somebody out of the league. I mean, suppose
There's no group boycott against any particular group of individuals in that situation. Where you have a minimum salary rule, there you're just, when you have a age eligibility, when you have an age floor, then you're prohibiting an entire group from being eligible for anything. When you have a draft or a minimum salary, you're not prohibiting anybody. You're just making rules to deal with the situations, to govern the entire, league.
I mean, suppose Clarett gets into the league, and before the Second Circuit can reverse. And the NFL and the union are upset about it. And they say to themselves, you know what? We need to prevent schools like Ohio State from alienating players like Maurice. So for the next 5 years, nobody can draft anybody from Ohio State. Because that's what's best for our league, to promote this. It's good for the league. It's bargained for. Can they do it? You obviously think they can do that.
Well, I mean, I doubt the union would agree to that.
But suppose they did. Can they do it?
I would think they could.
We have an expert, a friend of mine who's been a Teamsters lawyer for many, many years, Gary Bonsella, and it'd be interesting to get his input. I just asked him if he'd be kind enough to share his thoughts with us.
Well, the government legislates and protects people minor age, whether it's protecting dangerous machinery, not being able to drive a truck, not getting a CDL, and in the non-working areas, they're protected from pornography, not being able to make medical decisions. You're arguing that there should only be subjective judgments, that somebody is able to go into the NBA or NFL, they should be able to by whatever criteria there is. We have apprentice programs in various trades that set minimum requirements. What if there is Senator McCann who believes he can enforce the banning of steroids in Major League Baseball, says, okay, you've gotten 16-year-olds who want to play basketball. We think that's too young. Let's have hearings and we set a minimum age of 18 or 19 to play dangerous sports. That would put it on a par with other trades, other crafts, not as glamorous as football and baseball and basketball. But would that be something that you would accept, first of all? And second, why can't you have an apprentice program, as the building trades do, that set minimum age requirements to learn how to be a mason, a carpenter, a sheet metal worker, and have that as an accepted collective bargaining agreement? That is accepted in collective bargaining, and it is not challenged.
First of all, I think I would find it ironic if Congress were to say, you have to be 19 years old to play a dangerous sport, and yet you can be 18 years old and sent off to war. I mean, there's sort of the hypocrisy of it, right?
But pick an age, and Congress sets the age.
There's no conspiracy.
Your argument is that age doesn't matter, so if the person at age 15 has the ability of a LeBron James to play basketball, he should be able to do it without regulation from anywhere.
Age is a proxy, is what I would argue. I wouldn't say it's irrelevant. Some teams may value it more than others. I think it's up to the team to decide how they would value it.
But I'm saying that Congress then says, through its legislative power and the ability to control interstate commerce, that it has said that 18 is the minimum age.
Well, here's the difference. As Mr. Rosen says, if Congress sets that as a rule, then that's the rule. What happens in the NFL is that a group of teams have combined to keep individual teams from hiring these players, who the individual teams are otherwise eligible. So you've got a antitrust violation. You got a conspiracy. You got an agreement. You don't have that in the congressional setting. So if you had a congressional hearing that said you had to be 18 to play a dangerous sport, there'd be, and if they listed the sports as the NFL and the NHL, I think Congress can do that. I mean, I think there'd be hearings on it, and I think it may or may not pass, and
Might be an age discrimination
Right.
suit.
Yeah. What about the apprentice program where you have to be 18 to get into the apprentice program for sheet metal working or carpentry? Why is that not the same?
Again, the difference is that what Congress does as...
I'm taking it out of the congressional situation where the Carpenters Union and the Employers Association have a collective bargaining agreement that allows for an apprentice program that sets a minimum age of 18. Why is that different than what the NFL and the NBA have done with their players?
Well, I assume the apprentice program is designed to make sure that those who come into the league are adequately trained, right?
Right.
That's not the purpose of the age restriction in the NBA or the NFL. I mean, LeBron is just a perfect example for all of this. I mean, LeBron James is the best guy in the NBA. He was the best guy in the NBA when he walked in. He's 18. I mean, how in the world should LeBron have been forced to go through 3 years of college? Or it used to be 4 years of college. I mean, is there any question that if LeBron was on Ohio State basketball team, that it would be beneficial to Ohio State, it would be beneficial to the NCAA, it might even be beneficial to the NBA because you'd have a much stronger NCAA. But it's unfair to LeBron James. He's capable, he's able to be in the league. In fact, he's the best guy in the league.
So you don't want any age restriction at all, solely based on a case-by-case basis, regardless of the good faith bargaining between the Players Association and the league?
I don't. And the main difference is nobody gets drafted unless they are capable and ready to be in the league. No one gets put on the squad, makes the squad, unless they're good enough to be on the squad. No one gets a starting position unless they're ready to do it. And if they're ready to do it, why can't they do it?
So your argument would be that maybe the NBA should have let LeBron play at 16.
I wanted that case. I wanted LeBron. LeBron would have been the number one pick in the draft after his 11th year in high school. There's no question about that. He would have been the number one pick in the draft. Why couldn't he? What was preventing him from doing it? Because he would lose the opportunity to go through 12th grade? I mean, that's your argument, right? He would lose the opportunity to go through 12th grade. Believe me, you can go through 12th grade with $2 million in your pocket. You can do that.
We have another question from upstairs. We have to be kind to those above us. How much of this is paternalistic thinking? There are rules that prohibit drinking, for example, till a certain age. Don't you think the NCAA, the NBA, the NFL are protecting these young, I'm just reading this, egotistical kids from being in situations they aren't ready for, the fame, money, drugs, et cetera, and isn't that a fair and proper thing? Kind of like what Gary was saying, from we know better because we've been there. The labor pool knows itself better than anybody else. We think that's best for the kids.
Well, if the labor pool knew itself better than everyone else, then it wouldn't argue for that, because we've seen a near inverse correlation between how many years you spend in college and your propensity to be arrested in the NBA. So if they know themselves so well, then they would never argue for that. But moreover,
I'm still trying to figure out where the upstairs is.
Yeah, with drinking goes to public safety, right? I mean, there's a qualitative difference between worrying about whether someone's going to drink and drive versus somebody's going to cash a paycheck and dribble a basketball. And let's remember that policies for safety are far different than those for regulating behavior, just so that they can preserve the number of jobs for veteran players and preserve a minor league system where players aren't paid.
And I love that. I mean, that was the NFL's major argument. We're doing this for Maurice Clarett. Our age eligibility rule is for him. Give me a break. Come on. I mean, does anybody believe that the purpose of the eligibility rules are to protect these kids? Come on. They're all about money. That's it. And that it's about their own money and their own power, and that's it.
Thank God we have sports agents who aren't interested in money at all.
We generally care for the best interests of the children, absolutely.
Just to follow up and play devil's advocate for a second, how much money did Matt Leinert's agent lose when Leinert or Gill chose not to take that $65 million contract that he would have gotten this year for being the first pick in the NFL draft. How much money does that agent for Leinart lose this year?
2 to 4%.
2 to 4%?
Yep. Probably with Leinart 2, or maybe even less. Right.
But the fact is, with his college degree, the statistics show that a football player with a college degree will earn significantly more than a football player without a college degree, so maybe it's just deferred in terms of what the agent's lost.
Well, the deferral is interesting because, I represent baseball players. Of course, I'm on an NFL and NBA panel, but I represent baseball players, and the way baseball age eligibility works is a little different. You're allowed to go after high school, and if you don't go after high school, then if you go to a 4-year school, you have to go for at least 3 years or until you're 21. Every contract I negotiate for every baseball player I represent, I make sure that part of that contract gets him his education paid for at the end of his baseball playing career. It doesn't work that way generally in basketball or football, but as Alan and Mike say, you are free to go back to school whenever you want. But in baseball contracts particularly, and I'd be interested to hear what John and Mike have to say later about this, teams are very, very willing to give those scholarships. Why do you think? Because no one ever goes. No one ever uses it. There are very few who actually use that, but they're free to go. And I make sure to negotiate that in. And teams are willing to give that up in baseball because they say, look, if I'm going to pay for $20,000 in scholarship money in 2 years, well, you know what? That should come off the signing bonus. And that's an argument we have very often, but it works a little differently in that situation. But the end result is that you are always free to go back to school. By deferring education now doesn't mean that you're getting rid of it in the end.
No, but it might, if they're giving up eligibility, then they have to pay for it. And given the socioeconomics of the athlete, they'd be far less likely to go back and pay for their own college education.
Well, that's true. But remember, in the NBA, for example, there's a rookie scale. I mean, every contract that you sign in the NBA, well, with the new contract, is at least 2 years guaranteed with 2 team options. They're not making $5 an hour. They're making millions and millions of dollars. So they're going to be able to pay for it if they want to pay for it. The NFL, it's a little different because you're not having guaranteed contracts. But in the NBA, you're having generally guaranteed contracts, not all the time, but generally. And you're going to be able to pay for it. If they want to go back to school, they can go back to school. That's the end result. And by deferring it, I don't think you're answering that question.
Joe, we have two minutes left. I think it's appropriate because we've let you guys get battered here. And I semi-apologize, but not really because you know what you're getting into. For sort of a closing argument, if you will. And we'll all listen, and then maybe we'll take a vote and see who got the better of it. Okay?
Was there somebody else?
But we need to cut this off.
I need to cut it off.
So closing argument, and I think we should have a little jury pool here and see who got the better.
I'm sorry I wasn't able to really express my opinions, but I strongly, this is an issue I believe that has to get to the United States Supreme Court. There's a clear conflict in the circuits between the Sixth Circuit and the Second Circuit. I mean, I am just as convinced as I've been about any issue I've ever litigated that the eligibility rule of the NFL violates the antitrust laws, and let's just hope it happens one day soon.
I think if you look at all the data, all of the information we have in front of us, all of the past precedent, one thing is clear. It doesn't make sense to ban players out of high school going to the NBA, and there's a good chance that's also true for the NFL, certainly with at least a couple of years of college. The bottom line is that these rules are based on perpetuating a system where there's a free minor league system for the pros to develop players and where the players don't get paid. Thank you.
Okay, you make the call, as I said at the beginning. How many, we'll do it one sport at a time, how many are in favor of keeping the NFL rule the way it is? And how many have been persuaded by Alan that it should be changed? Alan wins. I won again, just like in the court below. All right, now we'll go to the NBA. Mike's case. How many think the NBA rule is okay as it is?
It's based on collective bargaining.
There you go. Well, you're not doing so well, Mike. And how many think it should be changed?
I think I win.
It's pretty darn close, but I think you guys both won. Right. So congratulations.
Preponderance of evidence, right? 51%, right.
Thank you. Okay. Well, let me just read one quote to you before we go, and this is something, and then we're going to take a 15-minute break. What brings us all together now that I think everybody is going to be coming is here, and what these guys are talking about is their passion for the game, and I think that's what unites all of us here. We wouldn't be here if we didn't love sports. And one book I would recommend to you in that regard is by Michael Novak, and you guys have probably read it or heard about it. It's called The Joy of Sports, and this is going to run through the whole day. And he says, well, what is the single reason we love sports? And he says, well, I love to see, and this is a great quote, the incredible grace that is lavished by people like Maurice Clarett, even on the simplest of plays. The simple, flashing beauty of perfect form. But even more what I love to see is that heart that refuses to give in, that refuses to panic, that seizes every opportunity and exerts itself far beyond its capacity to forge momentarily of its bodily habitat an instrument that seems to be of almost perfect will. When I see others play that way, I am full of admiration and gratitude. That is the way I believe the human race should live. When human beings can actually accomplish it, like these players on these fields, it is for me as if the intentions of our Creator were suddenly revealed before our very eyes, and as though into the fiery heart of that Creator we were able to achieve momentary insight. And that's why I thank these great players for doing what they do to inspire us to do great things in our ordinary lives. So on that, we'll take a break, and thank you very much.